Welcome to the Probate Realtor Show, your one source for selling and buying real estate through trust and probate. Hear directly from the best attorneys and trusted advisors on how executors and administrators navigate the probate process in and out of court. Being a personal representative or successor trustee can be a daunting task, and often beneficiaries don't have a clear plan. Let us help you make the right decision for your clients, your family, and your legacy. And now, here's your host, the probate realtor himself, Matias Baker Mazzucci.
Hello, everyone, and welcome to the show. Today, we are talking to Beti Bergman. Beti, thank you for joining us.
My pleasure. Thank you for having me.
Beti has an impressive resume, and she's going to share our knowledge with us. She has started her own firm, which is Peninsula Law, and she specializes in estate planning, conservatorship, probate. She, as we talked about her journey, you will learn some fascinating things about her. But before we get into that, Beti, can you tell our audience, what is a conservatorship?
Yeah, so a conservatorship is a legal proceeding that occurs when there is someone who cannot take care of themselves. So usually a loved one, a relative, it could even be a neighbor or someone that loses capacity, or they have a lack of capacity for some reason or another. Very typically, it could be someone with dementia. So that's a very typical probate conservatorship. But there are also other reasons. Sometimes people have developmental disabilities. And so when they become 18, and they cannot take care of themselves, they cannot make medical decisions for themselves. And if there's any finances involved, they don't know how to manage their finances, handle their finances. So that's called a limited conservatorship, as opposed to someone with dementia, older in life, and they lose capacity and they no longer could handle their finances, or again, make medical decisions for themselves, things like that. Then someone needs to get put in place legally to really make all their legal decisions for them, for the most part. There's differences between the two types of conservatorships I just mentioned, which I'm happy to dive into if you'd like me to, but that's generally speaking how that arises. Someone cannot manage their own affairs, and so someone needs to be legally in charge of them and make these decisions for them. And that's a legal proceeding in the probate courts.
That makes total sense. Thank you. That was a very good answer. Now, you touched upon something which is, the difference between a limited conservatorship. What are the difference between, a limited and non-limited conservatorship?
Yeah, so the limited conservatorships is, again, for the people with developmental disabilities. So a developmental disability means they really were diagnosed with something before they turned 18. So that's why it's called developmental disability. So oftentimes this is someone with autism or any sort of a brain deficiency, maybe since birth, or something that developed while they were an adolescent. So the parents were always usually taking care of themselves for the most part. But when they become 18, they're a legal adult, and they presumably should be able to make decisions for themselves, but they cannot because of that developmental disability. So once they turn 18, then the parents, it's usually the parents, but it could be someone else, they will need to file for what's called a limited conservatorship over that person. So then they can continue handling their affairs, managing them, making medical decisions for them once they become a legal adult. And it's called limited because it's limited in the powers that are taken away from the conservatee and given to the conservators. The law, there's a public policy in the law that just because someone is developmentally disabled, they shouldn't have all their rights taken away from them. So we still want to promote independence. And so that's why it's called a limited conservatorship. And there's usually 7 main powers that are involved in a limited conservatorship: determine residence, make medical decisions, access confidential records, make social and sexual decisions for the conservatee, marriage decisions, education decisions. So those are just the 7 main powers that are involved in the limited conservatorship. That are any of those powers that are granted would be taken away from the conservatee and given to the conservators. Now, you don't always have to get all 7 powers. Sometimes these conservatees are able to make certain types of decisions, so you can grant maybe a subset of those powers to the conservators and take a subset away from the conservatee. So that's a limited conservatorship. A general conservatorship is general, so it really does take away all the powers and rights away from the conservatee and grants that to the conservator. So that's a general conservatorship, and so that's kind of really all encompassing.
Thank you for that. Very good explanation. Let me ask you a question concerning the choice of conservator. I'm sure that when somebody has to make that decision, like you said, oftentimes it is a family member. I happen to work with a lot of professional fiduciaries who get appointed as conservators when there is no other option. When a client comes to you and they say, my mother or something, I'm afraid that she may be taken advantage of, giving the house away for $10 or whatever the circumstances may be. What do you feel in your experience? Is it going with a professional rather than going with a family member? What has been your advice to your clients?
Right. Okay. So that comes up a lot. And so when oftentimes conservatorships are contested, and sometimes the contest is because of whom should be appointed as conservator. Right. Now, sometimes that is family members that are kind of disputing each other about who should be mom's conservator, who's going to be in charge of mom and her mom's estate. And sometimes siblings, and oftentimes, unfortunately, siblings do not get along. And sometimes they're accusing each other of being the person who is financially abusing mom, let's say. Right. And so, and that does happen, unfortunately. Right. So that does happen. There's a family member that, okay, maybe is still living with the parent, and then the parent gets dementia, and then that family member starts taking advantage of that parent. Right. Or family member, and is living off of the parent and using the parent's account for their own benefit. And therefore, then another relative comes forward and says, okay, this person, our brother or whoever is taking advantage of mom. We need to get in there, file for conservatorship, and maybe move mom out of there or move the brother out of there or something like that. Right. But then that brother, of course, who the person or whoever is living with the parent and wants to continue those benefits, is going to contest that conservatorship and say, oh, no, I'm the one who's been taking care of mom all these years, and she trusts me. I'm living in the house, and I want to be the conservator. Now you got competing petitions for who should be appointed for conservator. Okay, and then maybe that brother that's in the house is accusing the petitioner, maybe a sister or whatever that's outside the house. She's the one that's been stealing, whatever. So now you got these two stories of accusing each other of who's stealing from mother. And then, so in a situation like that, oftentimes the best thing to do is put a private professional fiduciary in place, because as a neutral person, until we could sort all this out to see who is really stealing from whom and who's telling the truth, who is not. Because when this all starts in the beginning of these proceedings, it's all, it's he said, she said, nobody really knows who's the one that's really stealing, what's really going on. Oftentimes in a scenario like that, the person living with the mom most likely is probably the one taking advantage, and they want to, continue that. They don't want that taken away from them. But you don't know. I mean, it could be someone else that is. And so in situations like that, the neutral private professional fiduciary is always a great option, because they're neutral. They're professionals. They don't have the emotions that are vested in these families. And so then there's a neutral person there to figure it out, collect the bank account, and maybe do an accounting of the estate to see, okay, what's going on? Where has the money's been being funneled to?
That makes total sense. Total sense. Now, recently, over the past 3 or 4 years, the contested conservatorships have received, a little bit of a media attention. How do you, as a professional, when you find yourself representing the conservator, defend a contested conservatorship? What are the things that, you look for when saying, we got to put a case together here, somebody's contesting it?
It's so important in these kinds of cases. Transparency is very important, because everybody is accusing each other of, again, stealing or things like that. So when I'm defending someone like that is being accused of doing things, perhaps, I think transparency goes a long way. Everybody wants to see what's happening with the bank accounts, what's happening with the properties. And so that's very important to make a very good accounting and disclose everything to the family members, or who's entitled to, I mean, and family members sometimes are not entitled to see everything. If the conservatory is in place, it really is the conservatee's private information and things like that. Although accountings are required for the courts when there's an estate, the conservatorship, the conservator of the estate does need to file accountings with the court, and that is a public record. And so once that's not being done, suspicions arise. And so it's very important to prepare a proper full accounting and explain everything that's been happening in the estate. And so that just goes such a long way, because then everybody understands, is educated, okay, there's nothing being hidden. So that I think that's very important when you're defending someone, to always be transparent about everything.
So there are circumstances in which, you know, prior to, I guess, establishing a conservatorship, or while you're defending one, when you need forensic accounting and things like that, where you enlist the help of other professionals to be, you know, like, we need exact records of everything, et cetera, et cetera. So I'm assuming that you, like you said, you know, sometimes if a professional fiduciary is the right thing, you also work with other professionals to create like sort of a team to protect the client. Is that correct?
Oh, absolutely, absolutely. So we do have our go-to accountants who know how to do probate court accountings, to prepare a proper court accounting, to file with the court and serve on any interested parties that need to be served. Yes, so it's very important to have that great team of professionals that could do the things that are needed in administering estates. And for sure, the accountants are very, very important in this field to do the accountings, because probate court accountings have to be done in a particular way. And so you really can't go to just any accountants because they're not going to know the proper format. And sometimes people do it in-house. And if it's a very small estate, we could do it in-house. But when you have a lot of investments, a lot of real properties, maybe some LLCs and corporations, and so you're having to report things like gains and losses on shares of stock and things like that, you really want to have a really good professional accountant who knows how to do those probate court accountings. That is very, very key. Yes, because they can whip those around really fast. And yeah, and so that's important. So in all aspects too, like real property things, you know, have a good go-to realtors. And so yeah, a lot of things come up when you have to have good professionals in place, for sure.
That makes total sense. When you're establishing a conservatorship, what are some of the things that the court looks at, you know, prior to granting a conservatorship?
Oh, so the courts have to look at a lot of things. Now, when a petition is being filed for conservatorships, the court will appoint a counsel for the proposed conservatee. So that's one thing, because that conservatee, if they do not have capacity to represent themselves, they do need to have a voice in court. So the courts will appoint a court-appointed counsel for the proposed conservatee. And they will then eventually look at that court-appointed counsel's position with respect to the petition for conservatorship. So that's one thing the courts will look at. But the courts will also look at the probate investigator's report. So that's another thing that happens as a matter of course when a petition for conservatorship is filed with the court. There's what's called probate court investigators, and they are neutral. So the court-appointed counsel for the conservatee is an advocate for the conservatee, but a probate investigator is neutral, will go and meet with the family, the petitioners, the proposed conservators, the conservatees, and then make a confidential report to the court to recommend to the court what the probate investigator thinks should happen. And then the court will also do a background check on the proposed conservators. And so they will see, like, does this person have a criminal background or whatever, things like that. So they want to also look to see if the proposed conservators are going to be suitable and qualified to act in a fiduciary role. Can they be trusted? You know, and is there anything in the background that suggests they may not be a good fit to be in a fiduciary role looking after someone legally. So they will look at all that. If it's a limited conservatorship, then the courts will also get a recommendation from what's called the regional center. So limited conservatees usually are consumers of what's called the regional center. Regional center is a company that provides benefits to developmentally disabled people. So their county, they're in every county. I can't remember how many there are in California state, but people with developmental disabilities usually are consumers of these regional centers. Regional centers will provide things like respite care for the caregivers, or they will put them in day programs and a lot of different types of benefits that these developmentally disabled people need and can benefit from. They will get what's needed is also the report from the regional center as to what their recommendations are about which powers the limited conservatee not have and should be given to the limited conservators. So they'll look at that for limited conservatorships. They will also, in all conservatorships, they need a capacity declaration. So it's doctor's opinion about what are the limitations of this proposed conservatee. What can this proposed conservatee not do or do? And so then the court will look at that as well. So the court looks at a lot of the variety of things to see, is there clear and convincing evidence that this person should be under conservatorship? And should these people being proposed as conservators be appointed?
That makes total sense. Very, very good answer. Thank you. One last thing that I wanted to touch upon before we move on, the beneficiary rights. So let's say somebody is not contesting a conservatorship there, but they are, an interested party, like another sibling, and they're saying, look, I'm okay, we get a professional fiduciary, or Joe is going to be the conservator or whatever. But me as a beneficiary of the estate, as an interested party, I want to know what's going on. And in that case, you said some things are confidential. Obviously, the person still has a right to their own confidentiality. But what are some of the beneficiaries' rights in this particular case, in the case of a conservatorship?
Yes. Okay. So that's a great question, because the courts are there to protect these conservatees, and the system and the law and the public policy behind conservatorships is to protect these conservatees. But with that, it's very broad as to who can be called, who can be what's called an interested person. And so interested person could always come forward and say, okay, this conservator should be removed, or something's going wrong here. I want a copy of the accountings, things like that, just make sure that the conservatorship is running and being administered properly. So that's very broad what an interested person is. I think it's probate code for section 48, what qualifies as an interested person, but it's very broad. Relatives, friends, things like that. People can come forward to have a check and balance against this conservatorship, and they can file what's called a request for special notice, and then they can get served with things that are getting filed in the conservatorship estate or the conservatorship proceedings, so that they can have notice of what's going on. And if they see something that they think, oh, we got to object to this person's stealing from this conservator, stealing from the conservatee, then they can come forward and object to the accountings and things like that. But usually they have to have some sort of interest in the estate or something, but it's broad enough where someone can come forward if necessary.
That makes sense. Now, let's talk about your journey. First of all, I want to tell you something, because this is very interesting. So I have a kind of a running joke. I think it's a no. People talk about that. People say, like, the only reason why you become an attorney is because you're not good. You're not good at math, so you don't go to medical school.
Oh.
And in your case, reading your biography, that's absolutely not true. You are, you have a master, in mathematics, and so please tell me, like, how did you decide to go into law?
Yeah, that's kind of crazy. Okay, so yes, my background as far as education goes is in applied mathematics, and I have a bachelor's and a master's in both of that. And I love the sciences. So when I was going through school, that was my whole thing, was studying the sciences, physics, mathematics, all that kind of thing.
Mhm.
That was what I loved. I thought it was very, very fun. So when I went to grad school in mathematics, I think I already had in my head, yeah, I did. So I had a whole plan out. So I had a 5-year plan at that point where I'm going to get my master's in applied mathematics and then go on to law school. But I wanted to continue studying mathematics just because I enjoyed it so much and I enjoyed school. I just loved it. I loved it. So I wanted to continue studying, but then I chose the law because I thought, okay, I do need to have some sort of career that I think I can make money. I mean, and I hate to say that, this is not all about money for me, but I just need to choose a career. I need to choose a profession. And I thought, okay, what are my skill set? I think I'm very strong in logical thinking, analytical thinking, and then I love speaking. And so, I thought that sounds very exciting if I can be a lawyer and I could be, a trial lawyer and whatever. So that's kind of how it came about. And so when I entered my graduate school, I thought, okay, and after that, I will go to law school. And I had that. And it was interesting because I think I had a roommate at that time, and he saw that my plan out on my bulletin board. Like I had my plan of exactly how I was going to do that.
That is awesome. Now, in your journey, you joined the Los Angeles City Attorney's Office, right?
That's right. That's right.
So what made you decide to start working for the city?
Yeah, let's see. I think, well, before I was specialized in probate, trust, and estate planning law, I was a civil litigator. Okay. So I worked at a private firm, and I was a civil litigator, did, business torts, contract disputes, things like that. And I think the opportunity came up at the city attorney's office. A colleague of mine who worked at the city attorney's office suggested it to me. And I thought that would be a great use of my civil litigation skills at that time, and really kind of serving the public there. And I don't know, this sounded like a great opportunity and interesting. So that's how I kind of transitioned.
Nice. And then I guess as life went on, you took an interest in probate and estate planning and all of that comes with it. What caused the shift from, when did you decide, I got these litigation skills and now I'm going to move into another area of law?
Yeah, that kind of happened in an interesting way. I had my second child while I was at the city attorney's office. And at that point, I thought, okay, maybe now that I have 2 children, maybe I need to stay home more because I have these children, the 2 babies at home. And so I thought, okay, I should probably apply my skills to I was so family oriented at that time when I had my babies, right? I thought, okay, I'm going to then, I think, kind of translate my skills into helping families. Like how can I help families with children and things like that? And I thought, well, if I'm going to do something on my own and make some sort of transition into that, I really thought I was going to stop litigating and I will prepare estate plans for families. And I thought that'd be great. And I thought litigation would be so all consuming with my children. I had these 2 babies at home. Then I'll prepare estate plans for children and for other families. And so that's what I started out doing, which, by the way, was a huge transition. And now I'm certified as a specialist in this thing. So I'm all about probate now. But at that time, what I knew about this area of law was what I knew from law school. And so I really had to immerse myself and learn this whole universe of law and really know it well. And that's what I did. I thought, I'm not going to take any clients until I really master this area. And so that's what I did. But okay, so then I started out doing estate plans, drafting estate plans. But then I think one of my first cases where I think I was just going to amend someone's trust, and she was an elderly woman and she needed a trust amended. But then unfortunately, she died before we could get that amendment in place. And sure enough, her estate, which was quite a significant estate, a huge fights came out of the woodwork and people started fighting over her estate. And I thought, okay, I will litigate that since I know how to litigate it. And that case lasted for 4 years. And in the
Oh, wow.
meantime, further cases came in and whatever. And so I never stopped litigating.
You know what? You can't keep a good litigator out of court, no
I
matter
know,
what area of law you're going to.
I
This
know.
is
Somehow there it was, and it never stopped. It just never stopped.
let me so the way I end these shows, it's always like with a little, fun exercise. I have a list of like
Okay.
30 questions, 1 to 27, I believe, and
Okay.
1 to 30, and I'm gonna ask you to pick a random number, and I will ask you that question that from 1 to
Oh,
30.
interesting. Okay.
Yeah.
How about 23?
All right, 23. In your opinion, what quality helps best a person to get along in life?
Okay, I would have to say definitely listening. I think
Okay.
listening to, oh, I mean, getting along with others or just get along, like
In life,
function in
no,
life.
so yes, success, not to get along with others. Yes,
Oh,
doing well in life.
oh, doing well in life. Okay, so okay, so a totally different answer. Okay, so to do well in life, and I said this even when I was raising my kids, there's really two main components, I would say. I think you have to have some inherent intelligence.
Right.
That's important because, of course, if you don't have that, you're just not going to get there's going to be a limit to what you could do as far as being successful in whatever profession you may be in.
Mhm.
So you do have to have that, but that's not going to carry you the whole way, because you could have some people, and there's probably some people out there very intelligent, but they're not really doing much, right?
Right.
But then you have to have that inherent drive as well. You want that, you have to have that motivation within yourself too, to apply your intelligence or to accomplish something. And so I think that really needs to come from someone, again, inherently, because and again, going back to when I was, raising my kids, and not to knock any parents out there that do it differently, but I know a lot of parents would like just kind of micromanage their homework or tell them you got to study this and this for your test, things like that. I kind of took a different approach, and I just thought I guided them. The parents are there certainly to guide them and inspire and motivate, but I was not going to get into it on that level with them, because I felt they need to develop their own internal cues to drive themselves. And if you do that for them, one, they're not going to develop that themselves.
Mhm.
And even as much as you try to micromanage them or force them and tutor them or things like that, if they don't have those two components, the inherent intelligence and the inherent drive, they're not going to make it themselves.
Right.
And as a parent, you really can't do that much about it. You can try to motivate them, inspire them, but if they don't really have that within themselves, it's just not going to go. It's only going to go so far. It really
Absolutely.
is. At
Very
some
true.
point, they're going to be out there on their own, or they're going to be living with you until they're 40, 50, whatever. But there's only so much you could do that. For someone to succeed and accomplish things, they really have to have that within themselves and believe in themselves and have that confidence. You just have to have that. Otherwise, yeah.
That makes sense. Very, very nice.
That's what I think. That's what I think.
Beti, let me say something. I talk to a lot of attorneys. I work with a lot of attorneys. The majority of my business comes from attorneys that refer their clients to when the time comes to sell real estate. And I have to say one thing, and I belong to bars association, you name it. Like, attorneys are everywhere in my life. You really stand out. Your answers are so you're so to the point and so clear. I want to share with the audience as well, because wow, I'm very impressed, really. Like, your competency and the clearness. I have a belief that when somebody really understands something, it's easier to explain to others. I think we all know those things. Yeah. And I talk about these subjects a lot. And like the way you explain conservatorships, and I'm sure there is a plethora of other information within estate planning and probate that we could discuss. So thank you very much for sharing your knowledge. Like it's been a true pleasure talking to you. So thank you for that.
And thank you for all those kind words. And you're very welcome.
Absolutely. And they're absolutely genuine. And before I let you go, this show is going to be people are going to watch it on YouTube as well, but we also have it, you know, as a podcast where it's just the audio. So for people that want to reach you, what is the best for our audience? We're going to have your contact information in our show notes, no doubt about that. But for those who are just listening to the show, what is the best way to get a hold of you if somebody needs help in probate or conservatorship or estate planning?
I would say, call my office, and because we have a whole system in place to take calls and things like that. Wonderful. And set up a consult with me. And you can always email me too. Right. But we do have a system to do conflict checks and things like that when people want any consults or meetings, things like that. But it will get farmed through the right channels and things like that. So you can email me or just call my office, and I have people in place that could definitely set you up and connect us.
Wonderful, wonderful. Yeah. Thank you very much for being on the show. It's been such a pleasure. I have a feeling that we'll have you back, because this was a lot of fun.
Would love to.
Thank you so much. Yeah. Bye, everybody. Thank you for joining, and we'll see you in the next episode. Bye.
Bye.